Our next speaker is Joshua Metcalf, who is a trial lawyer at Forman Watkins in Jackson, Mississippi. Plaintiffs forum shop to get the most favorable judge, jury, and case law. The Supreme Court has established protections against these kinds of abuses, but plaintiffs continue to stretch the limit to what they can do. Joshua is going to discuss the recent Supreme Court decision in Daimler versus Bauman and how to take full advantage of the protections that that decision provides. Please welcome Joshua Metcalf.
Good morning. I can see your faces. The topic is personal jurisdiction. Tony, you're thinking, I just woke up. Why are you going to put me back to sleep? I think a lot of lawyers remember personal jurisdiction from their days in law school, and it's not necessarily a fond memory, and they thought, look, once I graduated, I could put that in the past and not really have to think about it again. So, the question is, why talk about personal jurisdiction today? And I actually picked this picture to put up as the first one because, number one, I think this is how a lot of defendants feel when they are in a jurisdiction they don't want to be in. There's no way to get out. You literally, you feel like you are being held at gunpoint. That may be how some of you feel today hearing about personal jurisdiction. But it's a really, really important topic. It involves fundamental due process. This is a subject, and the Supreme Court's decision in Daimler is one that really affects millions and millions and millions of dollars. And companies and lawyers who focus on using this decision to their advantage really can get out of bad jurisdictions in many situations. It's very surprising to me the number of lawyers who don't know about this decision, don't know about the Supreme Court's reasoning, and it's more than a year and a half ago, but it's one of these things that just keeps building over time. So I want to get everybody in this room, both in-house and at outside law firms, thinking about how they can use this decision to their client's advantage. This morning, I just want to go through just a little background on personal jurisdiction, just a little bit of a refresher. I want to talk about the Daimler ruling and kind of the history behind the case. Then talk about a few post-Daimler issues because it's winding its way through the district courts and appellate courts. And then give you a few practice pointers. All right, so this is the quick background. Just as a reminder, we have specific jurisdiction and general jurisdiction. Specific jurisdiction is very focused on individual conduct. If there is an accident in a particular state and there's a lawsuit about that accident, that conduct occurred in that state. The terms that the court uses and looks at things like purposeful availment is the connection to the state. Is it reasonable? And again, focusing on the conduct. General jurisdiction is all about, I can sue you for anything in this jurisdiction. Doesn't need to be related to the jurisdiction. If there is general jurisdiction over an automobile manufacturer in California, they could be sued about an accident in Poland if general jurisdiction exists. You probably remember references to International Shoe from law school. It's a 1945 decision. After International Shoe, there was not much discussion of general jurisdiction until 2011 when the Goodyear decision came down. And the Goodyear decision, the Supreme Court kind of shifted the focus from a continuous and systematic contact standard to one where they said, look, is it so continuous and systematic that the defendant may be regarded as being at home in that particular jurisdiction? And there's a big difference between, well, look, is it continuous contact with the state, or is it so significant that they're considered to be at home? All right, so that brings us to the Daimler case, which came down in 2014. And it involved Argentinian workers who had been employed by a Daimler subsidiary, Mercedes-Benz Argentina, during the 70s and 80s. And I don't know if any of you have read the ESPN, the magazine article, While the World Watched. It came out, I guess, last year along with the World Cup. It really goes through, this was a brutal time in the Argentinian history. It is There were just thousands and thousands of people who disappeared, unbelievable political unrest, torture, just horrible times. And some of those former workers sued Mercedes-Benz and sued Daimler AG in California to try and recover under the Alien Tort Claims Act. All right, so in order to understand how the parties and the companies relate to one another, I kind of put up here the corporate structure of Daimler and Mercedes-Benz USA and Mercedes-Benz Argentina. Mercedes-Benz Argentina is the entity that was alleged to have been a part of these atrocities during the 70s and 80s. Daimler is just the parent. Daimler is headquartered in Germany, manufactures vehicles. They did not have a presence in America. They made the vehicles in Germany. The vehicles were distributed by Mercedes-Benz USA. Mercedes-Benz was headquartered in Delaware, had its principal place of business in New Jersey. To give you a feel for some of the things that MB USA did, is particularly in California, because that's where these plaintiffs wanted to sue. It had multiple California-based facilities. It had a regional office there. Mercedes-Benz is the largest supplier of luxury vehicles in California. 2.5% of Daimler's worldwide sales came in California. So very significant activity in California. And for purposes of this decision, the Supreme Court said, we're going to assume that the contact that Mercedes-Benz USA has with California is the same that Daimler has. They made that assumption for this decision. And they said, is that enough? Is it enough to have multiple California-based facilities, to have all these sales in the state? Is that enough to get general jurisdiction over Daimler? Again, under the old test, maybe. There were minimum contacts. Yes, there were significant contacts. But is that good enough to establish general jurisdiction? The Supreme Court said no. Personal jurisdiction can only exist in the forum where you're at home. And now for the first time in this decision, they say at home primarily means where your principal place of business is or where you're incorporated. And absent exceptional circumstances, those are the only places that you can be sued under general jurisdiction. They said that the contact must be so substantial and of such a nature as to justify suit on causes of action arising from dealings entirely distinct from those activities. So they really have focused it in on those two factors, place of incorporation, principal place of business, and extreme other situations. So in Daimler, they decided that there is no general jurisdiction. You cannot sue Daimler in California for atrocities that occurred across the world. Now, that came down in 2014 and has started to roll out in a number of different contexts. I do a lot of asbestos work across the country, and we've got a lot of states where we see litigation, hundreds and thousands of cases being filed in those states over and over and over again. A lot of those states are very plaintiff-friendly forums, but the plaintiffs bear no relation to those states whatsoever. So you've started to see a number of these motions being filed where the defendants are trying to get into more favorable jurisdictions or get to the jurisdictions where the claims actually arose. So over the course of the last year, a number of decisions have come down. I want to kind of flag for you some of the ones that have come out that you need to be paying attention to these issues as they come up. The first one is the alter ego issue. And in the Daimler decision, the Supreme Court just assumed for purposes of the decision that Mercedes-Benz USA should be treated essentially as an alter ego of Daimler. And in rendering their decision in Daimler, they reversed the Ninth Circuit decision. And the Ninth Circuit didn't really appreciate that. They kind of took that personally. So earlier this year, a decision came down in a case called Ranza v. Nike. And in your typical general jurisdiction situation, you've got a plaintiff who is trying to get a foreign parent dragged into an American court, because a lot of times the foreign law is much more favorable to that parent. But But in the Nike case, you had plaintiffs who were trying to drag a foreign subsidiary into federal court in Oregon because they had jurisdiction over Nike in Oregon. And they had actually pursued a claim in the Netherlands and had not been successful, so wanted to come here and take advantage of the American litigation system. And the Ninth Circuit said, okay, look, most courts have not permitted plaintiffs to go after a foreign subsidiary through a local American parent. But it makes sense to us if the parent and the subsidiary are alter egos, it doesn't really matter which direction you go. So the Ninth Circuit kind of flipped that on its head and allowed, at least in theory, a plaintiff to pull a foreign subsidiary here into United States court. What they didn't allow, though, is that, I said they allowed it in theory, they didn't allow it in practice because they announced a very strong standard for finding an alter ego. And they actually, let me give you a little bit of the things that Nike did with its Netherlands subsidiary. Nike was heavily involved in its subsidiary's operations. They controlled the budget. They had approval authority for large purchases. They established human resources policies. They were involved in hiring decisions. They tracked the production of the subsidiary. They ensured that the brand was consistent all around the world. And they even required the subsidiary's employees to come to the United States. The court said, look, in theory, we could treat it as an alter ego. This is not alter ego conduct. So they did not permit the plaintiffs to bring this foreign subsidiary into United States courts. The next group of cases or type of case that I would flag for you is one that I've been doing a lot of work on in Delaware. And this is one that probably will have a lot of relevance to some of you because it's the waiver and registration to do business issue. Our companies are registered to do business all around the United States. You may be in 30 of the states. Some of those you may be very actively engaged in, some of those you may not be. But a number of courts have said if you register to do business in a state and if you appoint an agent for service of process, you are considered to have waived any objection you have to jurisdiction. And so I have a particular case that I'm working on right now where my client owned a paper mill in Mississippi where the plaintiff worked and was allegedly exposed to asbestos. Plaintiff sues in Delaware. My client doesn't have an office in Delaware, much less a principal place of business or an incorporation in Delaware. Doesn't have any employees in Delaware. Less than 0.5% of their sales last year, the relevant year, occurred in Delaware. And yet they're dragged into court in Delaware, and they filed a motion to dismiss, and the Delaware judge said, no, you registered to do business here, you therefore waived any general jurisdiction right you have. And a number of district judges and even circuit courts have said, no, a mandatory registration scheme does not waive your right to object to jurisdiction. There's a split, though. Another, good significant number of circuits have said if you register pursuant to that scheme, you've waived all rights. We have petitioned the Delaware Supreme Court for cert on that issue, and the Delaware Supreme Court accepted cert last week. So if any of you are interested in the registration as waiver or registration as consent issue, I would love to talk to you. We're putting together a number of amicus briefs. The National Chamber of Commerce is getting involved. There's some parallel pharmaceutical litigation in Delaware that has been subject to the exact same issues. And it really matters for those companies because, again, they have no relation to Delaware, but they're dragged into the forum because it's favorable to the plaintiffs. A couple of tips on using Daimler. Number one, don't waive it. If you file your affirmative defenses when you answer, when you move to dismiss, and you don't include it, you don't raise it to the court, it's going to be waived. You can sometimes stay in the case and conduct discovery, find out information about what the alleged exposures were, the real causes of action are, and bring it up at a later time, but you got to be very careful not to waive it. There have been a number of decisions where the court said, look, you litigated this case for 4 or 5 years, now you're just now bringing it to our attention, it's gone, it's waived. Number 2, prepare for jurisdictional discovery. You're going to have to support your motion to dismiss with very specific information on your company, what activities you have in that state, the amount of income that comes from that state, if you've got employees there, any kind of activities. So you really want to be proactive about figuring out what your activities are in your problem states and putting together affidavits from key people so that you can get out of there. Number 2, next point, maintain corporate formalities. And this is one of those issues that we've got a lot of litigators in this room, but there are business lawyers here, and this is, if the litigators don't talk with the business lawyers and make sure that the business lawyers are following the right forms, are conducting all the activities that you need to do to maintain the protections of the corporate form, you may be treated as an alter ego, you may have jurisdiction established over your company in a place where you do not want to be, but you haven't done the right things to get out of that jurisdiction. Review the corporate activity in those key jurisdictions. Again, in my context, it's asbestos. We had a client that was registered to do business in a particular state, did very little to no business there, was not worth the money they were having to pay out in settlements. And so the litigators and the business lawyers got together and said, well, look, we're going to withdraw our registration there. It doesn't make sense for us to be in that state anymore. Lastly, know the other jurisdiction. You don't want to go out of the frying pan into the fire. Sometimes you have jurisdictions that you don't belong there, but you'd rather be there than the other option. So make sure that you know the other jurisdiction. Got a couple of maps just showing where these Daimler motions have been granted. It's almost the whole country. I, in particular, do it in asbestos cases. There's not been nearly as many asbestos cases where this has come up, but it's very important. We spend millions and millions of dollars in settlements, so a huge, huge issue for us. And then I will just end with the slide. This is what we want when we get dragged into those horrible jurisdictions, those hellholes. We just want, let my people go. So hope it's been helpful to you. If you've got any questions, please come find me on a break.